Okay, good morning, and welcome to the third day of the Tokyo International Law Seminar. The first program for today is a lecture given by Ms. Rachel Davis under the theme of Navigating Business and Human Rights. Ms. Davis is a co-founder and vice president of SHIFT, the leading nonprofit center of expertise on the UN guiding principles on business and human rights. She has helped develop the UN guiding principles and now advises senior leaders from business and government on alignment with them. So with that, Ms. Davis, the floor is yours.
Thank you very much, and particularly to the Ministry of Foreign Affairs of Japan for the invitation to be here, and thank you to all of you for being willing to spend some time with me on the topic of business and human rights. Before I start, can I just ask all of our participants in the room today, who, coming to this discussion, who feels that they are familiar or have some awareness of the topic of business and human rights? Just a show of hands. Okay, that's it. Half, maybe some half hands. Has anyone in the room heard of the UN Guiding Principles on Business and Human Rights? Yes, more hands, great, okay, excellent. Also fine if you didn't raise your hand, and fine if you don't know about them, because that is the point of this morning's session. My name, as you heard, is Rachel Davis, and I've been working in this field of business and human rights for almost 20 years now. I'm an Australian lawyer by training with a background in international law, also working on our High Court and for our Attorney General's Department in Australia, but really my focus has been business and human rights. I was part of the team that advised the former Special Representative of the UN Secretary General, John Ruggie, on developing the UN Guiding Principles, and now I am the co-founder of a non-profit organisation that works to put the principles into practice, because it's very nice to have a UN document. We have many very nice, very important UN documents, but what matters is how they translate into practice. The practice of governments, the practice of companies, the practice of large banks, influential investors, and of course practices in civil society amongst NGOs and trade unions as well. So we work with all of these different partners in different ways at SHIFT in order to make these UN principles meaningful. And I think it's wonderful that the Ministry wanted to include this topic in this very important seminar, because it's a quite rapidly evolving area of international law and practice where the UN Guiding Principles really set a foundation for expectations and for discussion and for bringing people, very different stakeholders together around a table to try to reach common understanding, common solutions about some quite difficult challenges, but they are a soft law instrument. They're not a treaty, and so what we have seen in the decade since they were adopted is an interesting series of developments. I'll talk more about this, where we see the influence of soft law on state practice, but also on the practice of non-state actors, in particular business, because those are the actors whose conduct we are really interested in when we talk about business and human rights. So just a little bit, you have the slides, or you will have the slides after this session, so I won't go into this in detail, but a little bit about who SHIFT is and who we work with. And the point here is just to illustrate what I was saying, that what's different about us as a non-profit organisation is that we believe we need to work directly with the actors who are trying to put these principles into practice. So whether that is leading governments of the world, or whether it is leading businesses and financial institutions, these are some of the organisations that we have worked with and partnered with over the years. Before I keep going, are there any questions about SHIFT? We dive into the topic. Okay, and if questions come up along the way, I encouraged a number of you before we started, please do ask them, please do raise your hand, please come in. My intention is that we make this whole session interactive, so I'm not going to talk at you for a long time and then we have Q&A. I'm going to invite you to come in with questions the whole way through, because I think it's more interesting for all of us that way. So, I'd like to go through really three main topics in the time we have today. We have a little bit less time, but that's all right. What is business and human rights? So making sure everyone in the room feels comfortable with that first question. What does the authoritative global standard actually expect of businesses? What do the UN guiding principles say? And then what are the implications of, as I said, the hardening legal landscape? This is a soft law instrument, but it is turning into hard law quite quickly. What does that look like? What does it mean? When I say quite quickly, I mean quite quickly in the context of international law. As you will all know from your own areas of expertise, international law sometimes moves very slowly. Practice can move very slowly. This is an area in which I think just in the last decade we have seen very rapid practice. And that, to me, as an international lawyer, is interesting because that says that we have a series of challenges that are urgent and where many different stakeholders realised that we needed better answers. And that's what the guiding principles are trying to provide. So, what is business and human rights? I've just listed some, we might call them typical examples. Some of these may be familiar to you, some of them not, but I'll just take a minute and let you look through those. In some of these cases, we're talking about the actions of a company itself. So a factory releasing effluent into a local drinking water source. We're talking about, for example, private security forces that aren't properly trained in the use of force and carry out excessive actions against peaceful protesters. In other cases, we're talking about supply chain relationships. So companies that are sourcing products from a particular region where there is systemic sexual harassment against women workers in a factory context or in agriculture, for example. In other contexts, we're talking about some sort of problematic practices that come together to lead to a negative impact on people. So, for example, employers who might think that they're doing the right thing by holding on to workers' passports, charging them for accommodation, that's quite reasonable, but then also requiring them to work overtime because they're under pressure from the buyers to produce a lot of goods at very short notice. And suddenly we're looking at a situation which, under the ILO definition, would amount to forced labour. We're also looking at problems that can arise where a government is responsible for example, resettling local communities, and they carry that out without proper consultation or consent. And we're also looking at more complex and very sensitive situations where it may be an impact that results from how technology, which can have very legitimate uses, is applied in a particular context. So these are some examples to give you a sense of the kind of typical business and human rights issues that can arise. And it won't surprise you to know that in many of these cases, there's some different views about who is responsible for what, who should do what, who should take what action. Some of the topics that we spend a lot of time talking about these days in the work that we do at Shift include some really bigger challenges for the world at large, how business should respect human rights in the context of trying to move towards Paris-aligned commitments around climate change, the concept of a just transition, how do we transition our economy without leaving people behind or leaving people negatively impacted by that. Obviously, challenging political conflicts increasing throughout the world. I know that's an important topic of this seminar. But I want to take you back to 2005, which is when we started the process at the United Nations that led to the guiding principles. And I want to talk a little bit about what the situation was like in 2005. What we had seen in the 1990s was a very rapid growth in the complexity and the prevalence of multinational corporations, right? They were adopting new structures. They were setting themselves up through networked relationships that covered the globe. This is not a historical fact. This is not something that's always been the case. It's a fairly recent development in the last couple of decades. And in many ways, this was producing significant economic benefits. It was opening up markets, it was leading to jobs, it was producing growth. But what we also saw in the early 2000s was that it was leading to the externalization of costs, environmental costs, social costs, often onto people, workers, local communities who are in the sort of global supply chain of multinational corporations, but were not in a position of power and sort of had to accept whatever deal they were offered. So we were starting to see a real tension there between the benefits of globalization and the costs. And we also saw, pretty clearly, a lack of home and host state regulation. These were new legal structures, they were complex. Home states were reluctant to interfere with the competitiveness of their businesses. Host states were nervous about not being seen as a good investment destination. So we saw states taking, and this is a generalization, but taking a little bit of a hands-off approach. And this was true across really all jurisdictions. And this led to what John Ruggie, the author of the Guiding Principles, identified as a global governance gap between what was happening, the sort of economic development that was happening, and then how the costs of that development were being spread and how unequally they were being spread. So then we looked around at the legal landscape, and again, we didn't find any easy answers here. So we know that international human rights law does not generally apply directly to companies. There are some exceptions, particularly under customary international law, but there we're talking really about the most egregious harms to people, right? The worst of the worst. And even there, it still needs to be enforced through national courts. Instead, what human rights law expects is that states will take, obviously, their duty, their obligations under international law to ensure that non-state actors, including business, within the state's territory and jurisdiction, will respect people's rights. We saw very heated debates about the exercise of extraterritorial jurisdiction, always a sensitive topic, but particularly when it came to the question of these complex multinational groups. We saw that there wasn't really any clear case law domestically on other sources apart from international law, national law sources of corporate responsibility for those costs that might be externalized, as I said, so that wasn't clear. And we also saw in the area of state-investor contractual relations and investment some pretty clear tensions. So we collaborated with the International Finance Corporation to look at a range of state investor contracts. And it was the first, I think, comprehensive study, about 300 contracts, of the clauses that those contracts typically contained. This is back in 2005, so the world has changed a little since then, we hope. But we saw some really problematic clauses that were leading to countries like, I've just given two examples here, like South Africa, like Argentina, being unable or being challenged when they tried to pass laws that it was the legitimate prerogative of their governments to pass, to try to meet the government's international human rights obligations. These were being challenged by foreign, typically Western investors. So nobody had answers to this complex picture. So this is why Kofi Annan created John Ruggie's mandate. This lasted for 6 years. I was a senior legal advisor to John. He was based at Harvard Kennedy School throughout his mandate. And the creation of the mandate was sort of stepping into this set of problematic results, the positive results from globalization, but also problematic results, and stepping into this sort of legal, perhaps not a vacuum, but a pretty empty terrain on the legal side, to try to make sense of what could reasonably be expected of business and the role of governments in setting those expectations. And we were in a challenging landscape because civil society generally wanted a binding treaty that would take international human rights law obligations that apply to states and apply them directly to companies. Okay? some questions about that. On the other hand, companies were quite happy with the situation as it was, and they wanted to be left alone, and largely, again, I'm generalizing here, but they wanted to pursue purely voluntary CSR, philanthropic. We know that we need to make more progress was what we often heard, but we'd like to choose, we'd like to have the freedom to choose how to do that. And at the UN, member states couldn't work out how to move forward. There were some quite strong divisions there. So hence the creation of John's mandate. And John took a very careful and a very evidence-based approach because, as I said, these are complex issues, they're sensitive, they raise questions of state sovereignty, of the independence, the legal, separate legal personality of companies, about who's benefiting from globalization. There are many reasons why this is a sensitive topic, but it's a very important topic. So John set out to take a careful and an evidence-based approach. We spent 6 years carrying out research. We held consultations, more than 50 consultations all around the world with business, with governments, with civil society, and we discussed with stakeholders all the way along what a reasonable response to this problem might look like. And what we found through these consultations and discussions was that actually businesses, when you take all the different sectors of the economy, can impact many, many different, in fact, all internationally recognized human rights. It's not like this is just about labor rights, or it's just about land rights, or it's just about the right to health or education. It's all of these things and more. So complex. We also found, not surprisingly, that there was evidence of harms in all regions. This happens everywhere. This is not about, it may be particularly challenging in certain types of conflicts, certain types of contexts, including conflict and weak governance contexts, but it's not limited to those. We also saw evidence of harms in all sectors. Again, it's not just about one or two sectors of the economy. It looks different in different sectors, but no sector is immune from having an impact or potential negative impacts on human rights, as well as positive impacts. Right? That was where I started. This field recognises that the role of business should be, and often is, to contribute very positively to economies, to societies, but that where there are negative impacts, we need a better framework for setting out the expectations of what should be done about that, to minimise that in order to maximise the positive. So we concluded that there was a clear need for an authoritative framework that all these stakeholders could support, could get behind, and that could be practical, could help people deal with these complex situations when they arise. And that's what led us to the UN Guiding Principles. Before I talk about those, just let me take a couple of, just let me pause to see, how does this story, how does this analysis sound to you so far? Are there questions, challenges, concerns that you have about the way we saw and the way stakeholders talk to us about the landscape and how we went about understanding it? Does this raise any questions for you? I think there are mics, so please just put up your hand. Please, if you can let me know who you are, I would really appreciate that. I know you all know each other, but if you can just let me know who you are and ask a question or make a comment, that's very welcome. Please, we'll go here and then...
Good morning.
Good morning.
My name is Ibrahim. I'm from Egypt, the Ministry of Foreign Affairs. I would like to ask about the methodology you have adopted in reaching to the guiding principles. It was like a questionnaire to states or companies of what was their opinion and then how this worked through. Thank you.
Thank you. Very good question. There were many questionnaires. We tried multiple methods in order to get as many inputs as we could to this process over a 6-year period. So we sent formal questionnaires through the Geneva missions to capitals, asking for capital perspectives. We also held consultations in which we, in all regions, actually except in Australia, but that's okay. And we invited governments to those meetings, and we held meetings with individual stakeholder groups, so just with government, just with business, just with NGOs, so that we could hear, honest perspectives from each of those stakeholder groups. And then we held joint meetings as well, so that people could hear from each other, because we had to try to navigate a path that obviously took account of states' existing duties and also the perspectives that states were bringing to this process, but that listened to the other stakeholders as well. Please.
Good morning. My name is Tomoki Yanagisawa. I'm from Japan. I'm practicing lawyer here. I would just have a quick question about the particular why. So you mentioned that the mandate was given in 2005 in November. I was just curious to know what, if any, was there any specific event or issue that led to this mandate being provided in the year 2005? Thank you.
Thank you. Yes, I think there had already been an effort at the UN through the UN Human Rights Council to create what were called the draft norms on transnational corporations. And they really followed the approach that I mentioned before that civil society was particularly strongly in support of, which basically would have taken international human rights obligations and applied them directly to companies. But that raises a lot of questions, including the fact that not all states have ratified all human rights conventions. So immediately there are questions about, whose companies are going to be subject to which expectations. It's completely unclear how we would go about enforcing that. And it became evident at the UN that there was no support in the Human Rights Council for this initial approach. The Human Rights Council declined to engage with the report from the subcommission. And so we had states coming together, and the initial group of states that supported John's mandate included Nigeria, Norway, India, Argentina and Russia coming together. This was a different era in the Human Rights Council, coming together and saying we need a new way forward, and we need a way forward that is based on consultation and engagement with states and with business and with civil society. Great. So, the UN Guiding Principles, what are they? They are grounded in 3 pillars, and this was conceptually one of the most important things that John and the team of us working with him on the principles did, which was we said, okay, everything was getting mixed up together, right? Who should be doing what can we reasonably expect of different actors? We need to separate very clearly what we not only expect of states, but what states are already committed to do under their international human rights law obligations, so the state duty to protect against human rights harms by non-state actors, which includes business. This is articulated in many treaties. It's articulated in the work of the UN treaty bodies as well. But not much had been done to sort of spell out in practical terms, so what does that mean states should be adopting in terms of policies, legislative instruments, approaches to remedy? That hadn't really been crystallized, so that's what we focused on in the first pillar. But then we separated out the second pillar, the corporate responsibility to respect. And as I said, the UN Guiding Principles are a soft law instrument, so the UN Human Rights Council endorsed them unanimously, but they're not in themselves legally binding. But what we were able to do in this pillar was sort of crystallize what we saw happening across these different sectors and different regions, which was a recognition amongst some leading companies, amongst some business associations, investors, banks, from the demands of civil society, and certainly from some government legislation in different countries as well, that we have what we called a social expectation, that business should operate with respect for people. And that is I haven't met anyone yet who disagrees with that expectation. It's a fairly basic expectation. Executing it, getting it right in practice, is challenging. but the basic expectation that if we're carrying out business, we should do so in a way that respects our workers, workers in our value chain, local communities around our operations, people who use our products and services. That's a fairly common human expectation. So the corporate responsibility to respect crystallized that social expectation, and it said, great, that's nice that we feel that way, but we need to get more specific about what that means we think business should do differently from the way it runs its operations now. And I'll talk about that soon. The third pillar of the guiding principles was a focus on remedy. We know that where some of these harms to people happen in global value chains, it is extremely difficult for people to access remedy. That's due to a wide range of factors. We could have a whole discussion just on that topic. But there are very clear and distinct roles for states. States are already aware of their roles in providing access to judicial remedy, other forms of remedy through labour rights tribunals, arbitration, those kinds of routes as well. But companies themselves need to do more. They need to set up approaches in their own operations to try to tackle and respond to harms when they happen, so that we're not just, always waiting until things go wrong, then we try to get remedy. Everybody is unsatisfied. Right? The whole logic of the guiding principles was to try to push more effort into prevention of harms in the first place. But recognising that that's not always possible, things go wrong, and when they go wrong, we need better approaches to remedy. Any questions about this? I'm going to get into some of the specifics, but any questions about this construct?
Okay, good morning. My name is Kifilwe, and I'm from Botswana. So I just want to, from what you've been saying, I'm trying to understand what your organization, how it works on the ground then, with all these different stakeholders. Do you provide advice in terms of what companies or corporates need to change in their processes? And then with regard to states, like how do you speak to the practicalities of the work of shift? For me, it would make sense to understand what you do and relate it to the guiding principles. Thank you.
Happy to do that as I go into more of the detail. Any other questions at this point? Yeah. Is there a microphone? There's one here. Take mine.
I'm Kiran. I'm from India, but I'm here as Senior Legal Officer of Asian African Legal Consultative Organization. I was just wondering about the thought process that went into deciding the form of the outcome. That's the guiding principle. Was there ever talk about some form of hard law as against soft law? I know it's difficult in this area, but how did the terms of reference the representative received from the UN influenced this process? Thank you.
It's a great question. There's a whole book in that, and in fact, John Ruggie wrote a book about how he navigated the terms of reference he was given and developed the mandate and then developed the guiding principles. So the UN Guiding Principles on Business and Human Rights, which were, as I've mentioned, endorsed unanimously by the Human Rights Council in 2011, were the first, and as far as I'm aware, only time that the Human Rights Council has endorsed something that was not drafted by the member states themselves. They were consulted throughout, but this was not a text that was negotiated between member state representatives. And part of what I was trying to convey in painting that picture of where the debate started was to show why that kind of an approach could not make any progress, because there were very hard differences of view that it must be this, it must not be that, and a recognition, particularly by Kofi Annan and then by Ban Ki-moon, who renewed John's mandate, that we weren't going to make progress. It wasn't clear how to make progress with these very strong differences, and that it needed someone who was independent and who would follow a truly consultative approach to come back and present something and say, could this work? And that's what the member states accepted. They said, yes, we agree, this works. And this wouldn't have come up through a direct state-to-state negotiation, or not in the same way that that it landed. But the way we were able to do that over 6 years was to bring people along with us at every step, to be very careful that we would constantly, John was constantly going back, consulting with the core group of states, supporting his mandate, consulting with other governments, as I've said, consulting with business, consulting with NGOs, so that by the time we got to the guiding principles, no one was surprised. They had followed a 6-year process of exploring these issues and trying to work out what a good way forward could look like. There is currently an effort to develop a binding treaty on business and human rights at the UN. That's been going on for a few years now. The process is chaired by Ecuador, and it very much, in fact, it directly builds on the UN guiding principles. And what we said in the preamble to the guiding principles was that this intention was to crystallise a shared set of expectations that could then enable further legal developments. It wasn't intended to replace legal developments, but to support further legal developments, but around, as I said, a set of concepts that more people agreed on than when we started. So for me, as an international lawyer, this was an absolutely fascinating process to be involved in. And a very unusual one, I think, compared to many of the ways in which international law instruments are developed. So since 2011, we've had the guiding principles, and we've also had the OECD guidelines for multinational enterprises. These obviously apply, the guiding principles are global in the support that they've received from the UN. The OECD obviously applies to a narrower group of states and adhering governments, but they mirror the content of the guiding principles. So where governments do support the OECD guidelines, this is also a very strong hook for saying, and your businesses should follow these same expectations. So let's get into the detail and to answer our colleague's question a little bit more about sort of practically how do we work on the implementation of these at Shift. So I want to talk about what the guiding principles expect of business. I'll come to sort of what we see states doing and the work we've been doing with states in the next section of the lecture. But for now, I want to really dive into, so what does this change for business, right? What are we saying that business should do differently? So the basics of the corporate responsibility are that businesses need to prevent and address negative impacts on people in the same way that they think about other kinds of risk. So business is very good at thinking about reputational risk, legal risk, financial risk, right? This is what we expect of a responsible company. We don't expect a company to be sort of just doing whatever it wants and not thinking about risk management. So what we were saying was, and in addition to those issues, business needs to think about and manage risk to people that may not be factored into its own reputational concerns or legal concerns or financial concerns. What we increasingly see, and what I think this has changed in the last 20 years, is that the costs to people can also be costs to business. We have seen companies lose what we might call their social license to operate. Right, even where they have a legal license. We've seen communities say that's not good enough. We've seen workers say that's not good enough. So we know that sometimes a failure to think about impacts on people can lead to real legal, reputational, financial impacts on business. But not always, not always. So what the corporate responsibility to respect does is say, at all times, business should be thinking about and managing these risks. And they should be thinking about it in their own operations and in their business relationships. So back in the 1990s, when some of the early allegations came out about Nike's supply chain, for example, child labour, forced labour, the response from Nike headquarters was, it's not our factories, it's not our problem. We're a separate legal entity. What are you asking us to do about it? How unreasonable. The logic of the guiding principles, the logic of the corporate responsibility to respect, breaks that down and it says, we're not saying that you have a legal obligation to fix issues in completely separate factories over here. What we are saying is that you probably haven't looked, and indeed they had not looked, at the way in which their purchasing practices, the demands that they were placing on the suppliers, did that even enable the suppliers to pay a living wage? Did it enable the suppliers to make sure that workers could go home at the end of the day rather than having to force them, require them to work overtime? So looking at the ways in which the incentives, the decisions that are made in large companies do impact other companies in their value chain. And then really what the corporate responsibility to respect does is get into how, by focusing on risk to people, as I said, distinct from legal, reputational, financial, by recognising that, of course, we all start with compliance with national law as the baseline, but that may not be enough, and that often there is nothing preventing companies from going beyond compliance with the national law, where that sets a lower threshold for respect for rights. Where national law is in tension with respect for rights is, of course, more difficult. We can talk about that further as we go through. But in principle, there's nothing preventing companies from doing that. And that this is really different to managing environmental impacts or managing climate impacts. If there's harm occurring in one part of your operations or value chain, it's not enough to offset it by saying, but we built a school over here, but we had a nice program over here, but we did good things over here. If the core of your business model is, as I said, incentivizing suppliers to treat workers without respect for their labour rights. So there were some big conceptual shifts. You can see why we're called Shift. Big conceptual shifts that needed to happen within business to make this real. And so what we've been doing at Shift over the last decade, and there are many other organisations. Obviously, we're a small organisation, we're 20 people, we don't do this alone, there are many actors working in this space, is trying to show that this is possible, this is feasible, and that this is the approach that large companies, particularly large companies, not only, but particularly large companies, are taking. And it's that decade of practice now that has led into some really significant developments in EU law, in regional law, which I'll come to. But first, just a little bit more about what we expect from business. Before I go into that, any questions here? Let me just pause, check again. No? Okay. So the guiding principles set out a blueprint. Right? They try to be, as I said, more than just a high-level UN instrument. They're saying, here's how companies can go about meeting this social responsibility to respect human rights. And they use very familiar concepts that business uses all the time. We have a policy commitment. We embed it into people's incentives across the organisation. We carry out due diligence. The difference here is it's human rights due diligence. I'll say more about that in a minute. And we put in place grievance mechanisms, approaches for when things go wrong. As I said, things will go wrong. We need to be prepared for that. Human rights due diligence is really the key concept at the heart of the guiding principles and at the heart of all the policy and legislative developments that we've seen in the decade since they were endorsed. And this is what we certainly at Shift have worked on, and we've produced lots of publicly available materials about this that are on our website. Many other organisations in the business and human rights field have done that too. Examples of how companies in many different sectors are integrating human rights due diligence. Due diligence is a very common concept in business. You need to identify risks, you take action on the risks, you track whether what you're doing is effective, and you report about your progress. Right? That cycle, that due diligence cycle, very familiar. What's different about human rights due diligence, as I said, is that the risks you are going after are risks to people. They may also coincide with risks to the business, but that's not our primary focus here. So this is additional to the due diligence approaches that we already expect responsible businesses to have, and that they do have. But the focus is on people. And when we talk about people, I think the other thing that we've seen in the recent legislation that's been adopted is more clarity about who we mean. So the term that the guiding principles uses is affected stakeholders. Businesses are very good at listening to influential stakeholders, right? Loud stakeholders, whether it's stakeholders that have a financial investment and therefore, a legitimate legal interest in the business, whether it's governments, whether it's really big, loud NGOs, these are the kinds of stakeholders that can get businesses' attention. But often the people who are negatively impacted or who are at risk from business operations are not loud, they're not powerful, and they don't necessarily have they have no legal leverage over the business. And so those are the stakeholders that we are trying to get business to think about. And as I said, that can require a real change in how business thinks about its plans, makes its plans, who it consults with about its plans, and how it works out, whether or not it's doing things in the right way, in a way that respects people's basic dignity. So the affected stakeholders that we're focused on are obviously a company's own workforce in its headquarters, at other sites, workers in its value chain, local communities, and consumers and end users. And I've just given some examples here of the types of impacts, again, fairly common, we see these in news stories all the time, that may arise in relation to these different groups. For those of us who like to know, probably most of us as lawyers, what instruments we're actually talking about that underpin this concept of negative impacts, this was another way in which the guiding principles were able to navigate, as I said before, the sort of tension that can come up when we recognise that not everyone has ratified the same set of international instruments, but that we have a core set of instruments that all governments were willing to say, yes, it's reasonable to expect business to make best efforts to respect these human rights throughout their operations. And we're not asking business to respect them perfectly all the time in every case. That's not what human rights due diligence requires. The corporate responsibility to respect is a standard of conduct, right, rather than a standard of result. So we expect business to make reasonable efforts, best efforts, in order to do this. But the underlying instruments that we expect companies to be referring to are those core, the two core international conventions and the core ILO conventions in the area of labour rights as well. A brief word about making this manageable. So if we think about a complex multinational with a value chain, there are a lot of affected stakeholders. There are a lot of potential impacts. What are we really saying to business, you're expected to do to manage this? Well, that's where the concept of prioritisation or salient or most severe human rights issues comes in. So businesses can impact people in many different ways. And again, it's a standard of conduct. So we're not expecting business to take action on every single impact all at once. If you're a global company with a complex value chain, that's probably going to be beyond what's possible. So where business makes decisions, what the guiding principles say is make sure that you are paying attention to the most severe impacts on people. Again, if we're taking the lens of risk to people, where might a community's rights be most harmed? Where might workers' rights be most harmed? Make sure that you're going after what's often also the most difficult issues. Don't just go for what's easy or nice because it's close to you or you think you can fix it quickly. So this helps companies make it manageable, but it also makes sure that it demands something of companies. It's getting them to focus on the most serious risks. There are several ways in which a company can be connected to a human rights impact. I'm not going to go into this in in detail because we have limited time today, but these concepts drew on existing legal understandings, particularly from negligence law, domestic tort law, civil procedure, but they're not intended as, because the guiding principles themselves don't impose legal responsibilities on business. But basically recognising that there are different forms of involvement in an impact, causation, contributing together with others, or being linked to an impact in a value chain, and that these have different implications for how companies should respond. And this summarises the expectations in the guiding principles. I have talked with many different governments about this particular chart because it really clearly sets out what is it that we are expecting business to do differently, to take preventative action where they could be causing a harm, to remediate where they have caused a harm, to do the same where they might be contributing together with someone else. So the example I gave before of purchasing practices. Often the reaction in the past has been, I don't have a legal responsibility there. That's the supplier who chose to adopt bad practices. It's not my responsibility as the buyer to do anything about that. Or if we take the case of land impacts, a local community, the business's response will be, well, the government ran the process. I had nothing to do with it. You can't expect me to change what I'm doing in any way. What this set of expectations does is, again, treat the corporate responsibility to respect as an expectation that companies always need to meet themselves and say, okay, someone else may have done something problematic. A supplier, potentially a government process, potentially another business partner, a joint venture partner, potentially a private security company. But you always need to look at what you might have done or could do about that impact and the reasonable steps that you could take to change it. So have you looked at your own purchasing practices? Have you looked at what you're demanding of suppliers? Have you looked at whether you could make some change or take some additional steps that would focus on the most severe risks to people and try to mitigate them, again, in a reasonable way, without making you as a business totally liable, legally liable, for all the results, for all the impacts. And the final column, what we call linkage in the guiding principles, is basically recognising that in some cases businesses will have taken reasonable steps, but harms still continue to happen, right? And so we're going to acknowledge that they will remain linked. They should continue to pay attention to this, but they've taken reasonable steps. They've reached the limits of what we could reasonably ask them to do. And so this framework sets out expectations that, in our experience developing the guiding principles and in the 10 years since, have been seen as reasonable by governments, by business, and by civil society. Everybody might like something a little bit differently emphasised or pushed this way or pushed that way in how we apply this framework, but broadly, this framework reflects a shared set of expectations, and it's this that has directly informed the legislation and the policy developments that are occurring. Let me pause there and see if, again, there are questions, concerns, issues, people need extra coffee. Yes, please.
Hi, so my name is Tomoki Yanagisawa again from Japan. So my question is, you mentioned that these things are something that corporations should take beyond their own legal responsibility. So I think it is vital for these guiding principles to be internalized and somehow into a corporation's incentive mechanism that makes sense, that it would be more beneficial for a corporation to take these actions as opposed to not doing it. So I think the question is, how do you what do you think are vital factors for the corporations to internalize these principles in their daily actions? Thank you.
You're absolutely right. And I think there are many different reasons why companies have been incentivized over the last decade to start taking action in line with the guiding principles, but also those incentives are changing right now. So some of the incentives are the corporation's own values, right? Statements of commitment from its leaders, responding to expectations from its own employees, from its staff. Increasingly, we see particularly younger employees are clear that they don't want to work for a company that doesn't treat people with respect. Whether or not we use the language of human rights, that's how we frame it, but the core concept of treating people with respect, as I said, is pretty universal. We also see investors starting to ask companies, or they do, ask companies questions about how they are managing their impacts. And that's become, I think, that's grown in the last decade. We've started to see also the pressure around disclosure and reporting requirements. So whether they're imposed nationally in South Africa, in India, or whether they're, for example, or whether they're companies that are following international frameworks in their sustainability reporting, the sort of pressure of what they're putting out publicly is also coming into play. And we've seen campaigns by NGOs, campaigns by trade unions, drawing attention to where negative impacts have occurred and they haven't been appropriately addressed. So we've seen different sort of incentives, I think, operate on business, internal incentives, external incentives. What we see increasingly now is that the policy and legislative landscape is changing business incentives. So while I'm here in Japan, I'm meeting with a number of large Japanese corporations. Many of them are about to be subject to new legislation in the EU that will apply not just to EU headquartered companies, but also to large foreign companies operating in the EU in their global value chains. So that's a new dynamic. I think we've seen already in the last decade, just here in Japan, to take this example, an uptake by companies of human rights due diligence, but sometimes moving a bit slowly, or perhaps not responding quite as fast as we would want to the severity of the impacts that are at issue. But I think that the speed is about to significantly increase because of these different legislative developments. I'm conscious of time, so I want to maybe talk just briefly about this other key concept in the guiding principles, the use of leverage. So I said that the expectation of businesses is that they take reasonable efforts, right? Make their best effort to try to minimize negative impacts as part of their operations. And often that involves managing their relationships with business partners in their value chain. And in those cases, what we're really looking to business to use is their influence or their leverage with their business partners. It may be a joint venture partner, it may be a supplier, it may be a business customer that could create risks or pose risks to people. And what leverage is really about is staying in relationships and trying to change things for the better. So it's a very, I think, fundamental logic that is consistent with how we expect progress in human rights to occur, how we expect better outcomes for people to happen over time. That if we simply said, well, this seems very problematic, we don't like this relationship, we don't like this context, we're just going to stay away from it, we wouldn't see change, we wouldn't see investment, we wouldn't see, the kinds of positive human rights outcomes that we do see from corporate activity. So we want companies to stay in relationships, to invest in the relationships, but again, always with this view to how am I contributing to better outcomes for people, and how can I use my leverage to make sure I'm managing the risks to people, not just the risks to my business. I'll always manage risks to my business. Can I also make sure that I'm reducing negative impacts as much as is reasonably possible? And this is a really important logic, because I think quite often we see in the media, and certainly 10 years ago this was the case, you know, an allegation comes up that there's a problem, there's been harm done to this local community, or there's been, you know, harm done to these workers in this factory. And so large companies that feel that their, you know, reputation or brand is exposed will often say, okay, oh well, we're cutting the relationship, we're stepping back, you know, we've got nothing to do with that, we want to try to have clean hands. And that's not the answer that we want. We don't want them to step back and cut off relationships or not invest in challenging contexts or contexts that may require some more thought, some more effort. We want them to stay, but to use their leverage with a focus on managing risk to people, getting better outcomes for workers, for local communities, for others who are affected by business operations. So I want to mention this because I think sometimes when we hear the sort of discussion about business and human rights, people can assume, oh, that means a list of places we won't go, or a list of partners we won't have, or things we won't do. And that's not the logic of the guiding principles. The guiding principles say we want business to engage and invest, but with an awareness and a focus and with systems for managing, professionally managing, the way that those operations might have impacts on people and what to do about them.
Thank you for the lecture. I'm from Mongolia, and I have a question regarding the human rights due diligence. Because as in states, and we, the states are obliged to report to the UN about their human rights situation in their countries, in their states, because we're obliged, yeah? And isn't it the human rights due diligence for the country? And who will assess this human rights due diligence made by the corporates? And as I'm not doing the business because I was the former officer at the government, but as I personally know, this multilateral companies, multinational companies, they're coming to the countries where the human rights standards are low. That's why they decided to come and invest, and they're doing business there. I don't know, but who will assess it? Isn't it same with this state reports or the assessments given by the opinions, expertise opinions? Are they same or different?
Thank you. An excellent question. Let me go straight into the final section I wanted to talk about, and take a bit of time to answer your question, because I think there's multiple aspects to it. The first thing I want to say, though, before I talk about the changing legal landscape, is that ultimately these are choices, right? They are choices that business has made to operate in a certain way with a certain business model, and that means that you can also make new and different choices. And that's what we were looking at in the mandate. We were looking at how could we recognize that there are different ways to put in place systems in business, and that business can over time be required to put in place, which is where we're getting to now, 10 years after the guiding principles, that could lead to different choices. To still invest, to still come into certain contexts or certain relationships, but to do so in a way that says, we need to make sure we're doing that so that it will benefit people, not just so that it will benefit our profit margin. So I think I mentioned already the rise in sustainability reporting, which makes things more transparent. We've seen, for example, in the extractive sector, how both transparency about payments by companies and use of extractive revenue is a very important lever for making sure that we're getting to better outcomes for people. I've talked about investors who are increasingly focused on the S or the social in environmental, social and governance assessments of the companies that they invest in. But the really interesting and new development, I think, is this due diligence regulation. So we've been talking about, to your question, human rights due diligence is something that might be voluntary by companies, right? That we can have all these good reasons why they should do it, but ultimately it's still been a voluntary activity. What we're now seeing is the concepts in the guiding principles translated into hard legislation. This is a very detailed slide, and I'm not going to go into all the examples that are listed here, but it gives you, the point really is to give you a sense of the different types of legislative developments that may not name the UN guiding principles. Some of them do, some of them don't, but many of them are using really those same underlying concepts of human rights or due diligence systems for managing impacts on people and planet, social and environmental impacts. And that this is something that businesses can and should be expected to professionalize and operationalize and, to the good question before, incentivize, so that this is part of how business gets done. And some of these mechanisms are very different. They operate in very different ways. So the US, for example, takes an approach which is very much focused on the sort of leverage at the point of import and export control, looking at the restriction of goods that may be made with forced labour. We've seen this power exercised numerous times in the last few years. We see Canada, and under the US-Mexico-Canada agreement, both Canada and Mexico have set up similar systems, which are not as far ahead as the US system is yet, but again for checking with this sort of import focus. In Europe, we've seen the most activity. We've seen activity at a number, by a number of member states, but we've also now seen activity at the level of the single market, which I'll talk about more in a minute, which really, I think, is going to have significant knock-on effects, not just for companies in Europe and how they carry out business, but how they carry out business with their business partners abroad, and in ways that affect communities and workers far away from the European single market, and in a way that, again, seeks to treat them with respect. In the Asia-Pacific region, we've seen some sort of different approaches. In my own country, in Australia, there's an approach which is focused more on, again, reporting, using the leverage of required reporting. We see that being adopted. I think it's particularly interesting to see the stock exchange listing rules that are coming into force in China that are also about requiring, again, using different terminology, but asking similar questions about how companies are acting with respect for society and for the environment as well. I've been talking throughout today's lecture about human rights because that's the focus of the UN Guiding Principles, but increasingly we're seeing human rights and the environmental expectations on companies coming together. That's not surprising if we have two really overwhelming challenges as society right now. It's inequality and climate change. So social and environment. You know, we're looking across all different sectors and regions of the world to say, how are companies going to manage these twin challenges? What do we expect of them in their operations? So although today's focus is on the human rights piece, in these legislative developments, we see both really coming together. And just to mention the situation here in Japan, the Japanese government has had for some time now, these are not binding, but they are guidelines on responsible supply chain practices. And I mention them and I include them here because you can see, and we are seeing, the effect of even government statements of expectation of companies that are not binding legislation. You start to see the effect that that has on business behaviour. It's not magic. It's not a perfect equation. The government says this and business magically does it. Life might be a lot easier if that was the case. But you do start to see, I think, businesses responding to these clear signals from government that they need to be paying more attention to these issues. I'm going to talk a little bit more about what certain countries, including I think some of your governments who are here today, are doing on business and human rights. But before I do, let me just, this is a very complex picture, there's a lot in it. Again, we don't have time to get into all the detail, but are there questions about any of this? Thanks.
Thank you. My name is Ipian Amlilo from Tanzania. Thank you for the nice presentation, and I would like to appreciate the efforts that have been done to make sure that this lacuna is being taken care of. I have one question. You discussed something about putting some clauses in the contract. For example, in our country, we have these multilateral companies dealing with specifically in the mining sector. So there are so many impacts relating to human rights. But what is the best way of meeting these expectations? Is it through national legislations, or just even through this including some clauses in the contract? What's the best way of meeting this expectation? Thank you.
Thank you. I think there was another question as well.
Okay, thank you. My name is Ayako from University of Oxford. As I'm doing my research on the social responsibility of tech companies, especially on the misinformation, disinformation, hate speech, I was wondering, if any of those legislative environment related to the tech companies, because there are a lot of development, and especially in European Union recently on the content moderation responsibility of tech companies and social networking platform business, as the freedom of expression and then regulation of those companies really the views on that are really divided among states, especially Europe and the United States and other countries. So it is my question is there any reason you didn't really include those legislation in this slide? And then what do you think about sort of Brussels effect, or something for legislation may be impactful in not only one region but the other regions as well?
Thank you. So let me just take quickly your point on tech companies and impacts online or related to digital platforms. Absolutely. We ran out of space. On the slide is the technical answer. But indeed, the EU has been, the EU in particular, has put significant legislation in place with the Digital Services Act and others that use, again, this same underlying set of expectations, due diligence expectations of online companies. And there have been some fairly heated exchanges recently between CEOs of those companies and European commissioners about what the implications of those laws are for how much those companies should invest in, again, putting in place reasonable due diligence management systems for where there is, very predictable proliferation of hate speech or other forms of misinformation around the times of elections, and these kinds of experiences that we've seen happen now again and again. We know it's a risk, so what are the approaches that are being taken? And there are some, I think that there's more to do to bring, at the moment, impacts in the tech sector are being sort of treated and regulated quite differently from impacts in other sectors. I think that's okay. Over time we'll maybe start to see some more closer connection. But yes, I think it is the same underlying set of due diligence expectations. And when we look at what the major tech companies are doing, they are organising themselves around the UN guiding principles as well, and actually have been doing now for more than a decade. To come to the question about contracts and how to sort of set up the right series of incentives to change what happens in practice, and taking the very good example you gave of the mining sector in Tanzania. So I think what we see is that, back to that slide I shared about companies using leverage, that setting the right terms in contracts is always the foundation. When we looked at these investor-state contracts back in 2005, 2007, we were looking particularly at the use of stabilisation clauses and how those could undermine states' legitimate policy space. And often states were under pressure, right, from investors to include those clauses. But that's where the responsibilities of those investors' home state governments become so key as well, that it's important for home state governments to be recognising that that is no longer, or it should not be, acceptable practice, and that there's a direct tension between what some of those companies now need to do to meet this new and emerging legislation, and adopting very restrictive stabilisation clauses that, as I said, undermine a state's legitimate policy space to legislate for protection of social issues in its jurisdiction. And I know that that's a topic that you're covering in other sessions, so hopefully you'll hear a bit more about what current practice, or you already know what current practice looks like or how it's evolved, but getting the right terms in contracts is absolutely the foundation. But just as important as that is the systems or the processes that companies then have in place to, as I said, in a professional way, identify risks, mitigate them, and track whether or not that's effective. Because it's fine to make commitments that you'll have a positive social impact as a company through this investment, but if you have no systems to, as we would say, know and show how you're going to do that, if it's just sort of a nice sounding commitment that nobody can really hold you to down the line, then there's no way of checking that the business will actually make best efforts and contribute to positive outcomes. So that's why the due diligence concept and seeing a commitment by business to integrate that into its operations so that it's ongoing. Because if the investment is over multiple years, obviously it's not just about an impact assessment up front, it's about having ongoing management systems as the situation changes, and in order to be able to respond to that. We expect ongoing management systems for other types of risk from business. Why would this be any different? So I think it's both having the contractual clauses, but then the management system practice that builds on that. I want to talk specifically about the Corporate Sustainability Due Diligence Directive that's been adopted in the EU. I've mentioned this a couple of times, and back to the question about sort of how does Shift work to operationalise the guiding principles. So we've been very closely involved in the negotiations on this directive over the last 3 years. We've been provided expert advice to the negotiators in the European Parliament. We've also provided advice to a number of member states that either have their own laws or they are real champions of the UN guiding principles, like the Netherlands, like Germany, Sweden, but advising on how to turn what's in the UN guiding principles, what's in that soft law standard, into what is now binding single market legislation. And I'm very pleased to say that in May of this year, the directive was adopted, and it is substantially aligned with these international standards that many states were involved in supporting and consulted on, as I said, back in 2011, and that have been informing practice, business practice, financial institution practice for the last decade. The directive will apply to only very large companies initially. That's around 5,500 EU-headquartered companies, but these are major companies across all sectors of the economy. And it will apply to about 900 non-EU companies that have significant operations in the single markets. That includes, as I said, Japanese companies, but also a number of US and Chinese companies in particular, and some from other countries as well. But importantly, it's going to extend these expectations. It's not just going to say, operate nicely in Europe. That wouldn't add very much to the state of the world. It says, look at how you are using your leverage and how you are connected to impacts in your global value chains, in your operations outside the single market, just as much as in the single market. And do that in line with these international standards, which are now reflected in the directive itself. And so we were last year colleagues of mine from Shift were talking to businesses in Tanzania, actually in Kenya, in Bangladesh, and in Thailand about how businesses in those jurisdictions felt that this regulation would impact them. And I think, and we have a public report about the findings from those conversations. I think, not surprisingly, a number of them were, very anxious that the practices of their EU business partners need to change. Many of them feel that they are getting those kinds of pressures that I mentioned before pushed down on them, right? Oh, well, we need to tell our investors in Europe that we're respecting, human rights and the environment. So here's what we need you to do. You have to do this so that we can make this explanation. I think the experience that the businesses we spoke to shared with us reflects that sense of, downwards pressure in the value chain. And that's the opportunity in the directive. The opportunity is to change that sense of pressure and to say, if we're actually going to get to decent outcomes for workers and local communities in the value chains of companies that are covered by this directive, that's going to require new forms of cooperation between EU-headquartered companies and their business partners in whatever country they may be in. It's going to require looking together at how the business model and the approach to the goods or services that we're producing, where is that, externalizing costs, as I started off by saying at the beginning, in a way that we actually want to change. We want to make this more sustainable. We want to make sure it's benefiting local economies and the workers and communities that we're impacting. So there's a significant opportunity here in how the directive is implemented and enforced in the coming years to try to change some of those, the terms of some of those relationships and how companies collaborate in their supply chains to deliver positive human rights outcomes. There will be hard enforcement of the duty through civil lawsuits and national administrative supervision in across the 27 member states. So in the same way that the EU has set up structures, for example, for regulating privacy and privacy online, there will be with national regulators who have particular expertise and resources to oversee enforcement. That's the same thing that we will see here, except this could involve any type of impact and it could involve any type of sector. So it's a very broad-ranging directive. And importantly, and also connected to the question that our colleague was asking earlier, there are a number of steps by the EU to try to make sure that in addition to just passing hard regulation that will apply to companies, that actually EU member states start to pay some more attention to their internal policy coherence on this topic, so that where the EU is involved in development assistance or certainly in trade agreements, but I think we'll see it first coming really in the development assistance space, development financing space, that EU government efforts are more joined up and more supportive. That's always a big ambition in the EU, to try to support efforts in key production and sourcing markets outside the EU, outside the single market, that will again incentivize the kinds of outcomes that, as I said, this has the potential to lead to, but it's going to take a lot of work around implementation to make sure that it does lead to it in practice. Any questions about the directive in particular, or about what I've been sharing about legal developments? And then I'm going to talk, as I said, I'm just going to spend the last amount of time we have together talking about some of the efforts by governments that are represented in the room to work on business and human rights.
Thank you. I'm Chihiro. I recently completed my LLM at Cambridge. I have a question about your view on this this proposed UN Business and Human Rights Convention under study. Despite the fact that guiding principle is non-binding soft law, there are regional and national legislative bodies who are able and willing to make it into hard law. And in this situation, what would you expect to this possible new convention, international convention on business and human rights in terms of its content and function? Thank you.
Thank you. It's a great question. So I think for me as an international lawyer, my question is always, how can a new international instrument add value? What are we expecting it to either clarify or change about how this, this issue or set of issues is dealt with right now? And I think the treaty process is still navigating that question. So what do I mean by that? What I think we see in the environmental space is a recognition that if we're going to have a statement or a set of expectations in a treaty about how we will all act as states towards a particular shared issue like climate change. And this is similarly a shared issue, right? The negative externalities of globalization is a shared issue that we have. It's caused massive challenges in societies across the world. So if we agree this is a shared problem and we have a shared understanding as the guiding principles reflect of what to do about it, what will a treaty change in terms of the resources that are available to states, the support that's available to states, the kind of cooperation that happens between states to address these issues, the availability of technical assistance? So I think in the environmental space, we see a lot more attention to what are the kind of practical things that we can put around a new sort of shared statement of expectations that will make it more likely to be implemented and implemented well in practice. Because as you say, many of the underlying expectations already exist, and we know that many governments still struggle with having as many labour inspectors as they need. So how would a new international treaty change some of those really practical implementation questions? So I think we have a bit further to go to answer that. Great. And in the last few minutes that we have, I just wanted to flag the work that's going on in a number of countries to develop national action plans on business and human rights. Either plans are already in place, second plans are being developed, or related initiatives are being developed. And in preparing for this discussion with you all, I took a look in particular at some of the plans that have been developed by, Thailand, by Pakistan, by Vietnam, and by Kenya and Nigeria, just as a selection of countries that have taken action on this. And even though they're not taking the step that the EU has now taken, which is to adopt a directive and to put this into binding law, I think there's some really interesting elements that come out of those existing national action plans. And so this is not a comprehensive list, but it's just to give you a bit of a sense of some, because this may not be an area that you are directly involved in your responsible ministry, just to give a sense of what we're seeing in some of those national action plans. So, as I was just saying, we already have labour laws. We know that this is an obligation on governments, and we may have challenges in enforcing them or in staffing or resourcing labour inspectorates properly. But we see in the national action plans, for example, a focus on we need to go after and pay particular attention to workers who may be particularly vulnerable to negative impacts from business activity. So whether they may be women workers, migrant workers, workers with disabilities, LGBTI workers, workers in domestic contexts, in informal or home contexts, or platform company gig economy workers. And what can the government do about that? We see focus on really targeting issues that may be endemic in certain sectors, like sexual harassment or child labour, on what are some new approaches that governments are willing to commit to around those. Commitments to train public security forces in human rights, that's particularly relevant in the extractive sector, but also in sectors like agriculture and others, and infrastructure that have large operations that require security protection. A growing focus to the question that the colleague raised before about new risks, particularly from discrimination against marginalised groups in an online context. We do see consideration of mandatory due diligence laws. For example, Thailand has had this on the table for a little while now. Thailand is onto its second national action plan on business and human rights. But I think what perhaps in some of the other national action plans, there's a recognition, and I think Pakistan, for example, has a particular commitment to this, to look at how to introduce requirements, at least around some of the large projects, or the types of projects that involve multi-year presence of companies, that involve significant investment, and that involve some quite predictable risks to local communities or workers if they're not well managed by the company. We see most of the plans mentioning the role of public procurement and how this can, again, back to sort of what are the incentives that can operate on business. Business will always tell you in a conversation that public procurement is a significant one. You know, seeing the same signals from the state that it wants business to operate in this way is very important. Same with state financing of private sector investment as well. And then some broader commitments to, looking at access to justice, but these are normally challenges anyway that states have framed as needing their attention. So I think some of the other points are really quite specific to the action plans that we see on business and human rights. And the other thing I'll say is that not all of them are framed that way, right? It may not be. I think in most of the contexts I mentioned it is, but in some cases the government prefers to talk about it as responsible business conduct. That's the terminology that's used in the OECD guidelines, but it's the same set of underlying expectations. It's how do we get business to respect people and environment, and to professionalise the systems that business uses to do that. And the final point I wanted to conclude on is just when we look at the legal landscape on business and human rights. I started by saying sort of we had pretty empty terrain back in 2005. What have we seen that's changed? Well, we've certainly seen some interesting new precedents at national level around the responsibility of businesses for their human rights harms abroad. And there are numerous domestic claims ongoing as well, including some criminal claims. For example, in France, about payments made by Lafarge to ISIS, but that's not the only one. We've seen, I think, an increasing attention to the role of arbitration. Arbitration has been maybe a controversial tool in the business and human rights space, because very often the people who are negatively impacted in a business and human rights case are not parties to the agreement that triggers the arbitration. They have no say over who's appointed to the arbitral panel. You know, they're completely outside the process. So we saw an initiative to develop what are called the Hague Rules on Business and Human Rights Arbitration, supported by the Permanent Court of Arbitration, which are rules that companies and others can adopt, should adopt, in cases where their projects or investments may lead to impacts on third parties. And they set out some, again, reasonable expectations about how the arbitral process, following accepted rules and norms, but how it can be adapted to take account of these particular kinds of situations. We've also started to see some attention to the guiding principles, I think, and to those power differentials in stabilisation clauses that I was talking about before in certain sectors. And again, hopefully that's something that will be touched on in your more detailed discussions about that topic. And as I've just been explaining, I think we have really significant implications that we are yet to see about that will come from the adoption of these new mandatory due diligence laws and the changing legislative landscape more generally that is increasingly expecting corporate sustainability, human rights or sustainability, broader sustainability, due diligence as a norm of operating, and starting to really drive that into global value chains. Any questions about this? I know we are at time, but if there are any final questions, very happy to take them. Please.
Thank you very much for your talk. I'm Kentaro Minato, a private lawyer in Japan. May I come back to the previous section? You mentioned that the staying in relationship is a good way to bring the changes to the good outcome. So,
sorry, could you speak just a little more closely? Thank you. I can't hear. Thank you.
You mentioned that staying in relationship to is a good way to bring good changes. So I agree with that. But from the legal perspective, staying in relationship will bring more harm. Will cause more harm because the more violation will continue. So from the legal perspective, that will increase the liability, and so that the risk of the being litigated or sued will arise. So I think that there might be a contradiction between the staying in the legal aspect and the approach you mentioned. So how should we address these issues?
Thank you. That's an excellent question, and we could have a whole discussion on that. I'm conscious that I don't want to take time from the next lecture, even though we started a little bit late. So maybe very briefly, I would say it's not so much a contradiction as a tension, and lawyers are the ones who I think we need to think creatively about how to help their clients manage that. And this is why the International Bar Association put out very detailed guidance on the implications for corporate lawyers of the UN Guiding Principles on Business and Human Rights, because there's often a tension between the timeframes that a business is taking into account, and how to think about a short-term risk versus an investment over the long term that will, might affect its risk appetite, but might lead to better outcomes. And we definitely need commercial lawyers inside companies and outside companies to be advising with those considerations in mind. So that's a very quick answer to your very good question, but I think it doesn't have to be a contradiction. And with that, thank you. I think we are at time, so thank you all very much for your attention and your engagement. And it's been a pleasure to be with you today. Thank you.
Thank you very much, Ms. Davis, for your wonderful lecture and sharing with us where we are in business and human rights. Now we'll take a short break, and we'll resume at around 11 a.m. When we'll be given the lecture by Professor Mugumbe. Thank you.